Good afternoon, and welcome to the Saturday edition of the People Show with Mark Wallace, your host and facilitator of the Saturday edition called Our Legal Hour. We're going to be talking with the Cook County Circuit Court Judge Leonard Murray, who will be joining us momentarily. And today, as I put in the promo, we're going to be talking about the administrative review. And the administrative review is the part of the process that you can appeal fines that you've received for red light camera tickets, speed camera tickets, lawn, weeds, grass, all of those tickets that you go to the administrative review or the administrative hearing, whether it be at 400 West Superior or whether it be at one of the local Department of Revenue offices. If you're on the south side of Chicago on 95th and Jeffrey, if you're out west, they have a location out there. I don't recall the address of that location, but you get a ticket. You can go before an administrative hearing judge. They are not real circuit court judges. There are attorneys that are hired by the city to act as a independent trier of the information, right? But I have a rather more critical opinion about what their actual roles are. These are people who are hired and are paid a lot of money, a couple $100 an hour. And in many respects, I believe that those people, all they are robo signers to generate revenue for the city of Chicago. Now, I think it is necessary that we have oversight in place to make sure that we do the best that we can to keep our properties safe, to keep our properties clean, to keep them free of debris, and all of those things necessary to have a functioning community, a clean community, and that people are responsible. Yes, we have to have oversight. You cannot leave people unto themselves to govern themselves, because the reality is that we are people. We are people, and we have our human instincts to want to do whatever it is that we want to do. And so we have to have sets of rules that everybody has to apply, everybody has to live by, everybody has to be governed by. I am a proponent of that because I understand we as human beings need to have these things in place. If you don't believe that we need to have them in place, just drive your car to an intersection that has traffic lights and watch those traffic lights go out and watch what happens. Because typically what happens when you get to an intersection that you have traffic lights and they go out, we're supposed to do what is the honor system, that traffic going each way, one set of cars going in the other directions, another set of cars go. Watch what happens when the lights go out. You're not going to have everybody applying that same principle or governing themselves to that same principle. So I understand that we need to have these guidelines in place. It is very important that we have them in place and we have this kind of oversight in place so that we can have a functioning, safe, civilized community, society. Get it? However, there are overreaches, like things like red light cameras, things like speed cameras that are used for revenue generating purposes disguised as safety measures. There's been all the studies have deemed these as not producing the kinds of safety results that they purport to do, but they generate a lot of money. And so there are municipalities like the city of Chicago that, in my opinion, are addicted to these revenue schemes because they are easy generators. There are tax schemes that they can put in place or have in place without having to call them tax schemes. That's what they are. They generate revenue very easily because they've set the bar very, very high to ensure that, based on calculations of certain number of drivers, certain density, that you're going to return a certain number of violation, which will in turn generate a certain number of revenue, period. That's what it is. It's a calculation on how we can generate revenue. If it was not about revenue, they would have shut them down a long time ago. But it is about revenue. It's not about safety. But I'm not going to go into that. But we're going to talk about the process. So you get these tickets, you go to the administrative hearing, and you fight them at the administrative hearing. You argue at the administrative hearing, whatever your defense is, and you have your opportunity to go before an administrative hearing officer, and you lose there. There is another process. It's not over. That process is called the administrator review. And so we're going to talk about that, and we're going to talk about some other issues, but we're going to really focus on what that process is, because there are a lot of people who don't know that there is a process in place that allows for you, if you're not satisfied with the decision that is made at the administrative hearing, that you have another course. And so we're going to talk about that. Joining me now is Cook County Circuit Court Judge Leonard Murray, who is our answer our legal questions every week on the Saturday edition of the People's Show's Legal Hour. And this week we are going to be focusing on the administrative review. Judge Murray, how you doing?
Good afternoon, Mark. Doing well. How are you?
I'm fantastic. Doing well. Thank you very much for joining me.
Good.
So I want to get right into what we talked about early in the week, that we would focus on the administrative review and what that process is, and people have access to it. I think there's a lot of people who don't understand that process and don't understand that they have access to it if they don't like what happens at the administrative hearing. So why don't you give us some background on what that process is and what's available?
Sure. And one of the reasons that I reached out to you during the week and suggested that we cover this topic today is because there's quite a bit of misinformation and lack of knowledge in terms of what both the administrative hearing process is and then the administrative review process is. And what drove me to this is a case currently on my docket that involves an impounded vehicle. And I'm not going to get into the particulars of the case, but this person vehicle was impounded. I'm sorry, was disabled or had a boot on it. They came in. They went to administrative hearing to contest the booting of their vehicle. And just in case folks don't know, booting is where the governmental agency puts a device around. Normally, it's one of the front wheels of your vehicle, so that it is immobilized. And these things have been developed over time, so that for the most part now, unless you've got a lot of tools and maybe some very specialized tools, you cannot get this device off yourself. So it requires the agency that placed it on the vehicle to come back and remove it. And normally that's after a number of things could have happened. First, you could have normally you're immobilized because there's some unpaid fines related to typically parking violations of some sort. Failure to pay a parking fee, other types of violations, speeding, stoplight, red light, these things for which you're cited. And also understand this: any vehicle that is in your name, for which you are obligated as the owner of the vehicle, uh, can be immobilized. So even if, for example, you've got the requisite number of accumulated tickets against a vehicle and you own multiple vehicles, the city can immobilize a different vehicle. It's liability on the owner of the vehicle, not necessarily associated with the particular vehicle itself. So that's important for folks to realize. So if you've got tickets for which the city's policy is that if you have two tickets that are at least a year old that are unpaid, or and I'm talking city of Chicago, it may be different amongst the other municipalities, both in our area and also downstate. Uh, and let me remind me to go back and talk about the Illinois Constitution and home rule in a bit. Uh, but in any event, in Chicago, if you have at least two unpaid tickets that are a year old, or three unpaid at any time, they can immobilize your vehicle. So typically, once your vehicle is immobilized, and if you do not address the reason for its being immobilized within a certain period of time, then they will come and tow your vehicle and place it in the pound.
So I think what we need to do is to clarify, because there's a difference between parking tickets and there's a different application between photo enforcement, red light camera,
Yes.
or speed camera tickets. So
Yes.
if you have two unpaid speed camera tickets or red light camera tickets, you could be eligible for seizure.
Correct.
And that doesn't have to be a year old. It could just be if you have two that are unpaid that have lapsed beyond the due date.
Yes. 1 year, as I understand it. But if you have three unpaid tickets that are beyond the point in time when the city believes they're due and owing, then you can be immobilized at any point. It does not have to have reached a year.
Mm-hmm. Okay.
So, so in any event, the vehicle gets immobilized because of a failure to pay fines associated with the vehicle. Um, for whatever reason, the issue is not addressed, or at least uh, they may have gone to administrative hearing and gotten a ruling that says that they were liable. Therefore, the immobilization was deemed justified. And because of the length of time between the vehicle being immobilized uh, and remaining so, then the vehicle was seized uh, physically, meaning that it was towed away and placed in one of the various pounds that the city maintains around the city. Uh, so this, in this case, the person sought a hearing on the immobilization. That hearing resulted in a finding of justified. So therefore, the only way to have, at least at that point, um, to seek redress would be to file a petition for administrative review. Now, there is a statute in place, state statute in place that governs the administrative review process, and it not only pertains to matters dealing with fines and such that may be imposed by a municipal government. It also applies to other administrative processes. For example, if you have an issue relative to employment with a state agency or local agency, and you receive an adverse ruling, you have the right to seek administrative review. The important caveat here is that you must, and I mean you must initiate that review within 35 days of the entry of that order. Now, the exception there is service, because not in every instance does the respondent in administrative hearing walk out of that hearing with the order, the final order in the case. Sometimes those proceedings result in an opinion that then must be served on the respondent. So that may take some time. But in any event, the timeline is 35 days from whenever it is you're deemed to have been served with that order. If you don't initiate within 35 days, then the circuit court has no jurisdiction. And typically, the agency involved, the petitioner in the administrative hearing matter, will ask the court to dismiss because jurisdiction was not invoked within the timeline required. Uh, so I mentioned Illinois being a home rule state. That's important to understand because matters that deal with the issues of health and safety within a local government unit, that governmental unit has the ability to enact ordinances that govern that type of conduct within its political boundaries. So Chicago, as such, is a local governmental entity, and it has put in place through a tremendous volume of ordinances, rules that govern health and safety within the territory of the city of Chicago. That pertains to red light cameras, uh, stop signs, speeding, uh, parking violations, curfew, failure to pay fare on the CTA. Um, you've got to maintain the grass on your lawn not longer than a certain height. Uh, Also, conditions of your property. We don't have the time this afternoon for me to go through the entire city code, but any violation thereunder for which a fine has been enacted, the city can cite you uh, uh, and then try to impose a penalty. However, you do have due process rights. So that's the administrative hearing process that you mentioned early on in this session this afternoon, where you have a right to contest whether or not the imposition of a fine in the citation issued for an alleged violation is correct or not. And it is a so-called due process hearing where the city is required to uh, put forth its evidence, and then you have a right to rebut it. Bring in your evidence, your witnesses, your documents, your photographs, whatever it is you believe supports your position. So that's all the result of the Illinois Constitution allowing for home rule by local governmental entities. So that's how we have in place in Chicago these various uh, hearing facilities, and I think if I'm correct on this, there are four of them around the city that hear matters pertaining to code violations. Um, uh, and these facilities operate typically 5 days a week, and in some instances, some of them operate on Saturday. The only one I'm aware of that operates on Saturday is the hearing facility, is the Point of West Superior. But otherwise, the others operate on a 5 day a week schedule, usually from roughly 9 in the morning to about 4:30 in the afternoon. So let's go back to the situation of your vehicle being booted. So if that occurs, uh, you have a right to seek redress at one of these hearing facilities. to determine whether or not the booting was lawful and should have occurred, or the term typically used in the rulings that come from those locations is justified. And as I mentioned, there are two situations, factual situations that justify immobilization or booting. First is that you've got two citations that are at least a year old and unpaid. And the third and second is where you have three citations that at any time that are unpaid. They don't have to be a year. It's just whenever you reach cross that barrier of having three unpaid citations for related to your vehicle, it can be immobilized. So you would travel to one of these various hearing sites that the city maintains, uh, seek a hearing related to the immobilization, and typically, I tell folks when I see these cases that um, the hearing officers typically find the booting justified because the city records will demonstrate typically that you have either two unpaid tickets, at least a year old, or three at any time that are unpaid. So if that's what their records demonstrate, then they're going to conclude that the booting is justified. And I always suggest to those folks that when you seek review in the circuit court, your remedy really is going to the city and trying to determine what's the basis for their having immobilized your vehicle. What are the tickets that they believe are outstanding that are unpaid? Uh, because at our level, both at the hearing officer site or level, and also circuit court, um, if the records presented to us demonstrate that in fact that's a situation, then you're not going to prevail. Now, the way you attack that situation is to go back and demonstrate that in fact you did not owe those citations for which the city believes immobilization was authorized. And that requires going to the city clerk's office and asking for a list of tickets related to the various plate numbers that the city claims justified the immobilization, and then attacking them one on one. Now, sometimes what occurs is that uh, when they gather the information from the clerk's office, in many instances, there may be tickets that they were unaware of. And if that's the case, then you've got to seek a hearing on those tickets. You've been defaulted. So you would file a motion to vacate default, to set aside what's referred to as a motion to set aside the default, and determine whether or not you were served properly with notice of the tickets to enable you to seek a hearing on the merits. Now, even if the ticket allegedly was somehow placed on your vehicle, when you do not respond within a certain period of time, then the city, by its rules, is required to send out a mail notice of the fact that there is an infraction, alleged infraction, and therefore you've got to respond. Now that mail notice goes to the registered address of the vehicle. So whatever address you use uh, to register your vehicle, that's the location where the notice is going to be sent. And we have a very mobile society. So what happens? Some instances, people have relocated, but they haven't bothered to update their residency information with the Secretary of State. So therefore, that notice is going to go to the address where you have registered the vehicle with the Secretary of State. And if you fail to keep that, you're required legally, statutorily, to keep that residency information current. But if you fail to do so, and that notice goes to that address, then you really have no defense there because the notice was sent to the address of your last registration. So in that instance, you got a problem there. In that you didn't keep your registration address current. Now, it's important to know it's not the address that's on your driver's license. That's not the registration address. The registration address is the address which your plate, meaning your license plate, is connected to, and those don't necessarily have to be the same location.
Right. I do know that that is a problem with a lot of people who move and they do a change of address for their mailing address, but they do not go and do a change of address to update where their vehicle is going to be registered, because the vehicle and your mailing address are two separate issues that you have to resolve to make sure that you update getting notices for your vehicle.
Right, and many of us probably complain about mail service in the city. So just imagine if you have not only maintained your current location for registration purposes of your vehicle, but then you may be relying on the postal service to, if you in fact have given notice of change of address with them, you're relying on them to forward those notices, and I would say that's probably not a good idea.
Exactly. I would agree to that. So, folks, make sure that when you move, you have your change of address with the post office. Make sure you go to the Secretary of State and do your change of address. Now, I'm not sure, can they do the change of address? Has the Secretary of State, I don't know if you know the answer to this, but have they updated their website to where you can actually go online and do a change of address online?
I don't know the answer to that.
Okay, we'll find that out. Would be interesting to know if Alexa Janulius has advanced the Secretary of State to that point. It would be a good thing so that people wouldn't have to actually just go in and clog up the system just to change of address. I think that they should certainly have that in place. If not, we'll make mention of that to him and have them to look into making that happen. But it's important, folks, to make sure that you do get your change of address. If you are not sure, go down to the Secretary of State so that you can get your registered address. Because I know that people talk to me from time to time about red light camera tickets, saying that they never got the notices, they never got a piece of mail. And in many of those instances, is because their license plate is registered at a different address from where they live.
Yes, I see that all too often. And it's exactly as you mentioned, folks move, they're taking care of other matters, and they overlook the need to make sure that their vehicle registration coincides with where they actually live.
Yeah, let me ask you this. In the in the administrative hearing process, talking about tickets like red light camera tickets, speed camera tickets, person goes to the administrative hearing and they argue before the administrative hearing officer, who are not judges. They are not Cook County judges. They are administrative hearing officers who are lawyers hired by the city or the state to be this third party. What do they call themselves? Arbitrator? What? How are they listed?
They're hearing officers.
They're hearing officers
Yes.
on that's supposed to be independent hearing officers, but they're hired by the city. I'm not sure how you can be independent, but you're hired by the city. But okay. And they always just give you this bill. We don't work for the city, blah blah blah, and so forth and so on. Except for, very difficult to win a decision at that level. So they go there and
And
they get
also, Mark, those locations are not courts.
right.
So it's important that people realize you are not going to a courtroom. It's an administrative hearing room. It is not a courtroom.
Right. It's an administrative process. You're not going into a judicial branch at all. So it's an administrative process. So the rules are different. The rules are very different. However, if someone is found liable for a fine, whether it be a parking ticket, a red light camera ticket, or a administrative hearing ticket, whatever it is, and they're not happy with that decision, they have 35 days from the date of that actual decision to go and file for an administrative review. Can you define what the administrative review actually is?
Sure. As you know, those matters that we receive from the administrative hearing section, I initially preside over all those cases that have been filed in the Circuit Court of Cook County that relate to City of Chicago hearing office matters. And I always explain that under the city code, there are three ways by which you can protest a city ticket for an automobile operation. You can do it by mail, meaning you can send in your explanation as to why you believe you should not be liable for this matter by mail. You can also send in your explanation as to why you should not be liable for that matter by email. And the third matter is that you can request an in-person hearing. And that's where you physically show up at one of the various hearing sites. And I believe there are 4 of them around the city. And you request a hearing on whatever the citation is that you believe is improper. You would then appear before a hearing officer. It is a taped proceeding, meaning that there is a recording device that should be present and operable. And typically, there is no city witness that is present for most run-of-the-mill parking violations as such. And that hearing officer will describe what the alleged violation is, review the citation itself to see if it is technically sufficient on its face, and then ask for what your response is. It could be any number of things. I paid the parking fare, but for some reason it didn't register. I used my app to do it, or actually received a text message showing payment of it, and you can present that, and whoever it is that is presiding over your matter will evaluate what you have presented or your explanation, and then rule either liable or not on that particular situation. So in my experience, typically those folks who choose to proceed either by mail or email, those typically are not good outcomes. And I appreciate the fact that there is a sacrifice and inconvenience involved in showing up in person and requesting a hearing. But I think you fare far better if you actually take the time and go there and present your defense in person rather than trying to rely on how it would be interpreted from either a letter that you send to the city or an email. And I can also tell you that I've been involved in situations where the person has claimed that they sent in a protest by mail and the city claims we never got it. So that's also a risky means by which to attempt to overcome a violation where you send it by mail. We all have experienced situations where the mail never arrives. Now, the thing that's also important to understand on administrative review is that it is not a new trial. It is actually a review of what's already occurred. So we cannot receive new evidence. We don't take testimony. What you are able to do is argue as to why the ruling that you have received from the hearing section is incorrect and should somehow be modified, reversed, or otherwise changed. But you can't come in with a photo of whatever it is that pertains to the issue that you did not attempt to present at the hearing. Now, if you attempted to present it at the hearing, uh, and the record demonstrates that you did, but for some reason the hearing officer failed to include it, or the city at least failed to include it as part of the record, the hearing officer didn't receive it or accept it, then we can look at that to determine whether or not uh, it is something that should have been considered uh, in your defense. But if you have an after acquired document of some sort, photograph, whatever it is, that can't be considered on review because we are reviewing what occurred. We are not a trier of fact. We are a reviewing body. So that's important that when you attempt to defend and protest these tickets, that you come armed with all your evidence. And if you're not ready, then you need to disclose that at the very beginning of the proceedings so that the hearing officer won't begin the process and then tell you it's too late for me to consider what you may have but didn't bring along with you. So you need to announce as soon as you can that I have evidence that I'd like to present. I don't have it with me, so I need a continuance in order to bring those documents with me. Because if they go forward uh, and say that, well, we're into the hearing now, you should have made mention of that fact early on. I'm not going to consider it, and I'm also not going to um, allow you time to come back and present it. Now, of course, that is an issue or matter that we can consider on review and determine whether or not we should remand your matter for a new hearing, a de novo hearing, where you would have the opportunity to present the evidence that you somehow uh, uh, overlooked and didn't bring along with you when the hearing occurred. It's a discretionary call. Uh, so we would have to determine whether or not justice required and fairness required that you be given a chance to present uh, those documents in a new hearing.
So in the administrative review, when they come in, as you said, you take them all prior to them actually going before you or another judge in that in your department.
Yeah,
Now,
there's six of us, and everyone uh, hears these cases, including myself, on the merits. So I act as the assignment judge. So what I try to do in that setting is determine what is the issue, what is something that can be resolved more quickly by allowing a status date and for the parties, the city and you as the plaintiff, because please understand, on administrative review, you are the plaintiff. So you've
mhm.
got two burdens. You've got the burden of going forward. You've also got the burden of persuasion. Um, so many times by reviewing these matters in advance, I can determine what the issue is and whether or not I can set I'll enter the scheduling order that takes us out and sets up a date for hearing on the underlying matter. But many times I will also enter a status date, an interim status date, where if there's something that you can submit to the city to demonstrate that you should not have been cited, uh, then I also avail the court of that opportunity because it's always better to have quick justice rather than tardy justice. Uh, and there are a lot of situations where that occurs. For example, if your car is stolen and the folks who stole your vehicle ignored traffic signals while it's in their possession, and you can present the fact of your police report indicating the vehicle was stolen at the time of these violations, then there's no need to go forward on that for a hearing date because you can produce the death report to show when you reported it and the fact that these violations occurred while it was still in the possession of those who committed the criminal act. Uh, and many times, most instances, the city will agree to reverse those matters, and we don't have to wait the sometimes 3 months that it takes to adjudicate these cases.
Why? But there are some examples where this occurred and the city refuses to return the money, refuses to reverse the decision that are obvious. I can think of two. One, there was a woman whose car was stolen. She lived somewhere around the Cermak area, 22nd. It was stolen in the middle of the night. Her car was stolen in the middle of the night, and the people who stole the vehicle ran red light cameras or red lights at intersections where there were red light cameras. And she didn't report her car stolen because she was asleep. She had no idea that her car was stolen until the authorities came to her house the next morning to let her know that her car was stolen because they recovered the car. And she, but by the time that she found out that she had these tickets, they had assessed these charges against her, and for whatever reason, they were unwilling to reverse these charges. No, even with supportive information showing that her car had actually been stolen during that period of time.
So did you saying that she went to administrative hearing and they still found her liable for those tickets?
They still found her liable and would not reverse the decisions.
So did she file for administrative review
Yes,
and it was not reversed?
it was not reversed.
I'm surprised about that.
That's one case, and then there was another case where they clearly this person was supposed to get a warning, right? You're supposed to get a warning your first time. You're supposed to get a warning the second time you get the violation.
This is a speeding ticket.
This was on a speed camera ticket. So there he went through one at they were only about 10 seconds apart because he was going westbound, and then he made a northbound turn, and there was one right there. So on the first one, and then he passed the second one, but he never got the warning. He never got the warning. They assessed him a fine on the first one and a fine on the second one. So he ended up paying $200 when in fact he should not have received. He should have been assessed on the second one the $100. On the first one, it should have been a warning. The city even acknowledged it. They even acknowledged it, but refused to refund the money.
So he paid the fines.
He paid the fines, and then he got in contact with me, and I suggested that he go back to the city because of course the time had expired to where he could not go down and file for an administrative review because it had gone past the statute required time. So I suggested that he go to a media outlet to provide that information to a media outlet, and maybe that they could intervene, or they could contact the city, because sometimes even the news, they could contact the city and say, hey, we have this situation. They try and get it resolved even before they end up having to do a story. But in this case, the city just sort of dug in and refused to return the money, even though they acknowledged by a letter that it was an error?
That's that's a governmental agency, so it wasn't a judicial
Mhm.
uh, error, I suppose, involved in. That might have required some litigation, but it wouldn't have been in the context of administrative review, because that's not how the case proceeded.
Mhm.
That would have been uh, a case for reimbursement for violation of the city's violation of its own policy relative to
Mhm.
fines. But that would not have occurred in connection with administrative review, because it was, one, too late to protest the tickets at the administrative level. And then because they didn't do that, then you can't seek administrative review.
Right.
So it would have had to have initiated a law case, if you will, suggesting that the city should not have imposed a fine um, because the first ticket should have been issued as a warning, not a violation.
All right. So, all right, when somebody comes to for the administrative review, they come before you. Do you try to dispose of those before, or you look at those in terms of reviewing them? Do you look at them and are you trying to dispose of them at the point that they come to see or they come to you before going to assign them to another courtroom, or are you just providing them with the orientation of what that process is and then making the determination on whether they want to continue to try and appeal it, or are you trying to see if it can be resolved at the time that they come before you?
I would say all of the above. So I review the cases before the court call where they're up for the first time, one, to determine what the issue is. And sometimes you have folks, we have cases filed in administrative review. The clerk's office, unfortunately, doesn't always distinguish which section of the court the case should have been filed in. So sometimes I catch cases that should have been filed in another division of the court. So rather than allowing any delay in terms of where it should be administratively assigned, I will do that. We get a lot of cases involving employment, denial of employment benefits from the Department of Labor, sometimes discharge from folks who are in city government or even state government. Uh, so we don't deal with employment cases. We are exclusively dealing with violations that occur under the city code. So all of those other types of matters that are handled administratively, whichever side decides that they didn't like the outcome, then they file for administrative review. But many times, for whatever reason, they get assigned initially to our division, and then I catch those early on so that I can transfer them to the appropriate section of the court where they're typically heard. Um, and as well, those cases, those situations where I find out, for example, um, their red light tickets, and then on the hearing date, at least the intake date is what I describe it as. If the person who's filed the case suggested that the sample example you gave, where the vehicle was stolen, and if they got a police report to support the fact that those tickets, those violations occurred during a period of time where the car was in the hands of the thief, then those are tickets that should not be uh, 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 found against the owner of the vehicle, since it was a stolen vehicle.
But it
So,
should be, yeah, you would think that once they provide the evidence, that that should be an automatic, easy process for the city to say, okay, we're reversing this decision without a person having to even go through the administrative hearing process.
well, the problem there is that you don't customarily have a city lawyer who's in the room for those type of cases. It is typically the owner of the vehicle and a hearing officer. And I don't know if they feel less inclined to want to um, conclude that there's no liability here, so therefore I'm going to reverse or not. But you would think that common sense would prevail, and despite the fact that they're hired by the city, they're there to adjudicate the tickets that the city has issued, they'd be more inclined to use some common sense and say, well, there should be no fault here on behalf of the owner because it was the car was stolen at the time of these violations. But I see too many of those to know that that's happening over there.
Well, what makes it even more distrustful for citizens to trust the process, that when you have something as blatantly obvious as that it still seems to be a reluctance on the part of the administrative hearing officer, which is supposed to be this impartial participant in the process, who are just supposed to weigh weigh the evidence and make a decision. This is clear that this is by no fault of the owner, and it's an obvious thing that should just easily be dismissed, and it's not. And it's it's a real question as to why that problem exists.
Yeah, another point I think is important that folks realize is if you have a payment arrangement with the city of Chicago for parking tickets, if you default on that arrangement, uh, in my experience, they will not give you a new arrangement. So, so if you default, then be on the lookout because they're likely going to try to immobilize your vehicle. It is.
So if you default on your payment arrangement, then defaulting on that arrangement could actually the city then, if in default, it automatically goes back into
Collection.
collections,
Yep.
and you could then be eligible for a seizure.
Exactly. Yep. And I had a case where the owner of the vehicle suggested that they had a payment arrangement, and then they had a second payment arrangement. I said, well, I've never known the city to give someone two payment arrangements at the same time. So maybe you thought you had a second arrangement, but actually, in fact, you didn't. They never produced it, by the way.
Mm-hmm. Mm-hmm.
And as I understand it, ultimately the vehicle was seized, immobilized, and then apparently there was no action taken relative to the immobilization. And supposedly the vehicle was crushed. Now, because after a certain period of time, if there's no action taken to somehow reinstate or pay off the debt, then the city will tow the vehicle, put it in the pound, and at a certain period of time, they will in fact sell it or have it crushed. So I don't know all the facts yet in this particular circumstance, but what I'm told at this point is that the vehicle was crushed. And the other thing that happened is that this particular owner, for whatever reason, after once having had a hearing where the immobilization was just found justified, they continue to go back to administrative hearing, and I don't understand why. Because that issue was adjudicated,
Mm-hmm.
and they didn't file the case for administrative review until beyond 35 days, and I, I just don't know yet what went on and what led them to believe that they should continue to go to administrative hearing. in order to try to resolve the dispute. At that point, once the order justifying immobilization was entered, you should have gone to court. In fact, I tell people, yeah, you got 35 days, but as soon as that order is in your hand, you can walk over to the Daily Center and file that case the same day.
Right.
So there's just a lack of knowledge out there. And one of the reasons why I thought it would be important for us to discuss this topic today.
Yeah, I think, you're right, because it is one that even people who are trying to appeal these or don't really understand that even when the information is provided to them, because when you go to the administrative hearing, they tell you if they find you liable, you have 25 days to pay it without it doubling or adding additional costs, but you have 35 days from that same date to file the appeal. And I try to get people to go in to file the appeal sooner than later, because if you get past that 25th day, then the city can, based on the way it's set up, they can double your fine. But I think that if you go in and you file, and this is where it kind of gets into where I think that the process needs to be looked at, is that if somebody gets in files before that 25 days, then all actions should cease until it's been fully adjudicated at the administrative review period.
Well, the city ordinance provides that the city's collection actions cease once a case has been filed to contest the administrative ruling. That's part of the city ordinance.
But what happens is that when they file the administrative review, of course, they don't get before you or get before the judge. They don't get before you for another at least 30 days, right? 30 days or whatever the time frame is. By that time, the 25 days has expired, and the city send out notices saying that the fine has been doubled.
Yeah.
I think that if somebody files that administrative review and they notify the city, all action should apply the same way that it does in any other normal judicial process.
Well, again, the city ordinance provides that their collection actions are stayed once a case for administrative review has been filed.
Mm-hmm.
Now, internally, I don't know how they effectuate that process, but it's in the city ordinance. It's their own rules that say that we stand down once we are aware of an action being filed, and process in these cases is one that is effectuated by the clerk of court. The party themselves don't have to serve the city. It is done by the clerk of the circuit court. The city is required to be served, respondents in administrative review required to be served by certified mail by the clerk of court. So once you file the case, that whole notice process is one that the clerk of court undertakes, and the plaintiff in administrative review is not responsible for that at all.
Okay. I think we're going to have to spend a little more time on this process, because I think it is an area that more people are unaware of this process and what it is. And I think that we need to spend a little more time on it when we maybe next week when we come back. Now, speaking of next week, either we can pre-record next week's show, because I'm going to be in Florida next week for we have our town reunion, but we do have the ability to pre-record so that people can get the information. So I can talk with you about that a little bit later on to see what kind of availability of time that we have during the week that we can pre-record it and have it to air at the time that we have our normal show. So the studio allows for that technology to take place. But I think that It's really important for us to kind of clarify this, because there seems to be some, I don't know if I want to say it's confusion, but I certainly think that there are people who don't think that they have an opportunity or any chance of prevailing on this. But I think if they have more of the information on, just what the tools that you have before you, that if you utilize them, then obviously you have an opportunity. But you don't have an opportunity if you don't utilize the tools and you don't show up.
Correct.
Yeah. All right, folks. Well, that's going to do it for us this week. Talking about the administrative review, we're going to continue that conversation. But one of the things that I want for us to go further into, Judge, is evidence. What evidence can people bring at the administrative review? Others, they recognize it as the appeal process, right? To appeal the decision that was made at the administrative hearing. What evidence can they bring in? Can they bring in new evidence about, or can they only discuss what was discussed and decided on at the administrative hearing? But I'd like for us to elaborate on that the next time that we come back.
Okay, that's an important topic.
All right. Okay. All right, folks. We're going to talk about that when we come back on the next time with Judge Leonard Murray. Thank you very much, Judge. Have a great week, and I'll talk to you later about pre-recording that next show.
Okay, great. All right. Thanks, Mark.
All right. Thanks a lot. All right, folks. Well, look, that's going to do it for us for this week, for this week's edition of the Legal Hour. Hope that information that Judge Murray provided you on the administrative review. We're going to have a part 2 of this, so that we talks about the evidence and what you can bring and what is permitted and what is not permitted to bring before the court, and what that timeline looks like in the process. You got to be patient with it to give yourself an opportunity to have it decided by a real judge, because you didn't like the decision that happened at the administrating hearing officers at the administrative level. All right, that's going to do it for this week's People Show. Look, we got a lot of stuff that's going on. Make sure that you tune in Monday night for the Monday night edition of the People Show. I will be talking about what's going on in the Trump trial. Also going to be talking about and weighing in on the Stephen A. Smith interview that he did on Fox with Sean Hannity, and how factually off Stephen A. Smith was, and how Sean Hannity manipulated that for, of course, their own agenda. We're going to talk about that on the Monday night edition of the People Show. Make sure you tune in at 7 o'clock Monday night.